Welcome back to Radio Entrepreneurs. Again, my name is JDavis. I'm the host of Radio Entrepreneurs and also CEO of Mage LLC, management consulting firm in the Boston area dealing with entrepreneurs and leadership and business in transition. Our next guest, it's been many years and we like to check in regularly with Mark Furman, shareholder at the law firm of Tarlow, Hart Rodgers for the segment Entrepreneurship and the Law. Welcome back, Mark.
Hi, Jeffrey. Great to see you.
You too. And always, as you know, I always look forward to seeing you and making small talk offline. What's the subject today, Mark?
So I wanted to talk about a misconception that some business owners had. I get asked this question. Their company and they get sued personally. And they say, how can I be sued personally? Because I have a corporation or an LLC. And the answer is that having a corporation or an LLC entering into agreements protects the owners from personal liability for contractual obligations. In other words, claim of breach of the agreement entered into by the company. An exception would be if you personally guaranteed your company's performance, which sometimes folks are asked to sign guarantees if their company's being granted credit. But in the absence of a personal guarantee, you're not personally liable. However, that corporate shield against personal liability doesn't apply to other non-contract liabilities. And there's a whole laundry list of claims that can be brought that you're not shielded from personal liability in the event you were personally involved in what happened. So I'll just give you a few examples. If a claim is asserted that you made a misrepresentation, even if you made it on behalf of the company, they can bring a claim seeking to hold you personally liable as well as the company for fraud or misrepresentation. If you're an owner of a closely held business and you have other owners, under Massachusetts law, you owe fiduciary duties to the other owners, not just to the company. So the company could sue you personally. Your co-owners could sue you personally for breach of fiduciary duty. Let's say you have a company that the nature of the business is to buy, renovate, and sell real estate. And you do it a number of times, and you see an opportunity to buy a piece of property, and you said, I'm really tired of my partner. They never do any of the work. I do all the work. I'm going to just do this myself. You may end up getting sued for usurping a corporate opportunity. That's another area where it comes up. When you freeze out minority partners, you end up getting sued personally, and the corporation is not a shield. Corporation may end up being a defendant too. Let's say you are accused of wrongfully terminating a co-owner, but the corporate shield won't necessarily apply because, once again, that's considered a kind of a breach of fiduciary duty. And, if you defame somebody, even though you're doing it as for your business, you say false things about a competitor or something like that, you may end up as a defendant along with the company in a suit claiming defamation, commercial disparagement. If you're accused of unfair or deceptive business practices or trade secret misappropriation, or certain environmental laws, or certain unpaid taxes or wage claims, there may well be personal liability or harassment or abuse claims in the workplace, personal liability. And so in a whole host of situations, there is no corporate shield. So what do you do to protect yourself? Once again, you need to have a trusted insurance advisor so that many of these things, not all, many of these things are things that can be insured against. A horrific accident that you're involved in could give rise to personal liability, and as well as corporate liability. So having adequate insurance is not going to cover every potential risk, but it's going to be able to cover some. And so you want to thoughtfully think of, what your coverage is. Lawyers can be helpful in this too, because if you don't have insurance that covers a claim, the insurance company is you're self-insured, and frequently it's the defending the claim that is even greater than the liability exposure, because we have a legal system that Massachusetts treats any claim that's $50,000 or the same. So if it's 50 million or 500 million or 55,000, it's all the same procedure in this world of emails and texts, and it's just of documents in almost every case. So I urge everybody to make sure their coverage is up to date, just as you want to make sure other legal documents are up to date. Estate plans, LLC operating agreements, shareholder agreements. Don't think of these items as just an expense to you. They're a cost saving for you in the event that the future goes in a way that you don't expect. And I must say that in the life spirit of business, for many businesses, there's a oh my God situation which is awful. So try to be prepared as best you can.
Now, the insurance, you probably covered this, Mark. It also will cover legal costs, correct?
Yes, and some, let's $1 million policy, which is not a lot today. There are two kinds of policy. One would have the fees count against the coverage. So every dollar you pay in legal fees reduces the coverage. But there are also policies out there that you have the $1 million plus defense costs. And laws relating to insurance are complicated too, but you're absolutely right that coverage of legal fees is critical. It doesn't just cover your lawyer's fees. It'll cover, when it applies, things like expert fees. Expert fees are substantial, particularly if there's a damage claim. that is not just arithmetic. And when you deal with claims like lost profits, and those have to be calculated, you need typically a lot of work done by experts. Sometimes on industry standards, you need experts. What's reasonable, you need experts. So it's not unusual to have cases with more than one, and sometimes several experts in order to properly defend the case. And we can talk about this at another time because it's another whole topic. But one other area I'll just mention, Jeffrey, is when even for contractual claims, when the corporate shield can be pierced. In other words, it can be set aside and the owner found personally liable for corporate debts that weren't guaranteed. But we'll deal with that in another segment.
I think that's good. We'll keep that on the list of our producer, how to pierce the corporate shield. Mark, very good protection advice for entrepreneurs who seem to feel that they don't do anything wrong. That's one of their shortcomings. If somebody wants to know more about liability issues and protections as a shareholder, how do they find you?
I can be reached at 617-218-2025 or by email, mfurman, Furman, at tbhr-law.com.
Great. And for our listeners, we can see Mark again next week and every week on Radio Entrepreneurs.